Hi, and welcome to today's GFVGA's webinar, Post-Election Power Lunch. The last few months have seen an extraordinary amount of activity in the fruit and vegetable world, including 2 hurricanes, a pivotal election, and a flurry of court activity centered around the H-2A program. Today's webinar is intended to provide us with a snapshot of how all of this activity will impact our industry going into 2025, and we have a great panel of experts on hand to highlight these topics. We'll start off with Bob Redding from the Redding firm in Washington, D.C. Bob will discuss the impacts of our most recent election, how this affects important topics like the Farm Bill, trade, and disaster relief. From there, we'll go to Kimberly Hermann from the Southeastern Legal Foundation, who is representing GFVGA in our case against the Department of Labor. Closing arguments are due later this month, and Kimberly will update us on the fight to oppose DOL's most recent overreaching rules. And finally, we'll hear from Chris Schulte, the newest member of the Phillips legal team, who will give us a look at H-2A cases pending around the country. So without further ado, we'll kick it over to Bob.
Thank you, Chris. Thanks for including me in the webinar today and for all the association does for our fruit and vegetable growers throughout the Southeast. I would like to discuss briefly the election results relative to specialty crops, Farm Bill, seasonal imports, a little bit on ag labor, ag economic assistance, and natural disaster assistance. We could quickly get lost in the number of acronyms that will be discussed between now or today and December 20th, when Congress will likely go home after they have passed a fiscal year, 2025 appropriations package. So there's a lot to be considered. It's not that all of this came to a head here at the very end of the session of the 118th Congress, but a lot of things have been delayed. So pushback, Farm Bill, seasonal imports, ag economic assistance, and now on top of that, we've had a hurricane or natural disaster assistance. So first, let's take a look at the what's happened after the elections. We'll talk briefly about the administration, House, and the Senate. Today's a big day for both the House and the Senate. For the administration, everyone's waiting on a USDA secretary nomination, and then we'll start looking at other appointments in the Department of Agriculture, but also with regard to the U.S. Trade Representative and the Department of Labor. The Trump team has been meeting for months, working on lists of personnel, potential personnel, as well as also reform policy positions for various agencies. This includes USDA. For example, House Chief of Staff has been heading up the personnel side of USDA for these last months of the election and serving as a transitional co-director for USDA. That team has been building a list from secretary all the way down to Schedule C political appointments. Secretarial names have been talked about as potential nominees, been Chairman G.T. Thompson of late, Kip Tom, who is headed up ag for President Trump, Cindy Hyde-Smith of Mississippi, Senator from Mississippi, who was served as a Commissioner of Agriculture in the state of Mississippi, Sid Miller, who's a Commissioner of Agriculture in Texas, and yesterday and today, Sarah Fry and Charles Herbster, agricultural specialty crop grower with Sarah and agribusiness on the other side with Herbster. At U.S. Trade Rep, a lot of people wanted to see Bob Lighthouser come back for round 2. I'm not sure that's going to happen, but he has a host of trade deputies that were there with him that would make great U.S. trade reps for the specialty crop space. 2 in particular, I think we should watch. Jameson Greer has been talked about. He's an attorney with King and Spalding. He was involved in the Section 201 blueberry case at the International Trade Commission. If you'll recall, U.S. Trade Rep Lighthouser encouraged the Section 201 case and did not turn out well for blueberry with the ITC vote, but that was demonstrated that that set of deputies and, of course, U.S. Trade Rep Lighthouser were very familiar with our seasonal import problems. Greg Dowd has also been mentioned. has also been mentioned as a possibility. He worked with Senate Chairman Pat Roberts with the Senate Ag Committee. And we also had, he also is now serving as a dairy association head. Looking at the House, 219 to 211 as of today, relative to the ratios in the House, Republicans control, you only need 218 to win. House Ag Committee for Republicans should stay the same unless Chairman Thompson leaves to be secretary. Austin Scott will still be vice chairman of the committee and subcommittee chairman of the Title I and Crop Insurance Subcommittee, which is one of the most powerful subcommittees on the committee. Other specialty crop Republicans, David Rouser from North Carolina, Kat Kamek of North Central Florida, both have been active with specialty crops, fruits and vegetables primarily. House Ag Dems, we're hopeful David Scott can hold on to his ranking position from Georgia. He's been supportive of our efforts. If David does leave the ranking member position, others talked about are Jim McGovern of Massachusetts, who's ranking member on the House Rules Committee, Benny Thompson of Delta, Mississippi, Chantel Brown, who's an urban member from Ohio, and Sanford Bishop will remain as a senior member of the committee. He's been on the Ag Committee for a very long time. Leadership races are today in the House for the Republicans. Speaker, Majority Leader, and Whip will stay the same. The real race is for conference chair. If you'll note that Congresswoman Kamek, who's the current conference chair, has been nominated by the president to be UN ambassador. And we have now two people running. We had three people yesterday running. One dropped out, but Kat Kamek of Florida and Lisa McLean of Michigan are both running. Kat has been very supportive of our Southeast grower efforts in all spaces, seasonal, labor, and in our general farm bill proposals. We're in good shape on the House Ag Committee. House Ways and Means on Trade, Jason Smith from Missouri will remain chair. He's very pro-ag exports. But we also have our same team in place that have been helpful to us on seasonal and very supportive. Greg Stubbe of Florida, Terry Sewell of Alabama, and Vern Buchanan of Florida. We've worked two committees we think are important for us ongoing. One of those is the House Energy and Commerce Committee. Georgia may have two subcommittee chairs coming up. There are two members, senior members of the committee from Georgia, Rick Allen and Buddy Carter, who both should be considered for subcommittee chairmanships, and Kamek may as well. On the Democratic side, Darren Soto of Florida, who has certainly been supportive of us on seasonal issues, may be a ranking member. Judiciary is going to be the big one for this cycle, dealing with ag labor issues. Barry Moore of Alabama, who defeated Jerry Carl, now represents not only central Alabama, but also the southern part of the state, which has the bulk of H-2A employers. Barry serves on ag and judiciary. Now, why is this important? It's important because the Ag Committee this past cycle sent an ag labor package, a template of for H-2A reform to the House Judiciary Committee. House has remained Republican. The chairs for House Ag and hopefully ranking members will remain the same going forward, House Ag and Judiciary. And we're going to need supporters on the committee to carry forth the H-2A package, at least the template, moving forward on H-2A reform, hopefully this Congress. And more would be certainly could be helpful in that process. Sanford Bishop will remain ranking member of the House Ag Approach Subcommittee. He has been very helpful to us, not only on research, but other key areas. Robert Adeholt of Alabama is chairman of the Labor Subcommittee on Approach and has been supportive of language, including language in the FY 2025 appropriations bill, trying to address some of the many issues we've had with the U.S. Department of Labor actions. Andrew Clyde is also on the Approach Committee and has led on ag labor letters in the House of Representatives in support of Georgia and Southeastern ag employer interests. In the Senate, big day today. They're going to announce soon the new majority leader. We haven't had a majority leader race amongst the Republicans in, I think, 18 years. Senators Thune, Cornyn, and Rick Scott are up. Likely Thune, but we won't know until the vote happens sometime later this morning. John Bozeman of Arkansas will take over as chairman next year. Ranking member will be Amy Klobuchar of Minnesota. This will be very good. They're a good combination for production agriculture. Chairwoman Stabenow was more focused on specialty crop initiatives, but was not necessarily sympathetic to our seasonal import provision in the Southeast. Klobuchar doesn't have as many specialty crops as Stabenow, but she is very pro-production agriculture and has worked well with Southeastern interest in the past. We'll know later on movements, but we'll have some shifts on Senate Ag. Some member increase, some may drop off. We'll know later as we get into first of the year on the committee and final makeup. The trade issue is handled by Senate Finance Committee in the Senate. We are underrepresented in the Southeast on the committee, and we need to watch that committee and see if we might pick up a slot moving forward for the next Congress. Important for us are any movements by Senator Warnock and Ossoff. Senator Warnock will likely stay on the Ag Committee. For H2A interest, we need Senator Ossoff to stay on Judiciary. That's important to us, as well as Tom Tillis of North Carolina. Senator Rubio has been appointed to or nominated for the Secretary of State slot, and we don't know yet who might replace him for that Florida Senate seat. Senator Rubio has been the most active on our interest and has led the efforts for our seasonal issue in the Senate relative to the Federal Advisory Committee that USTR is now formulating. So we'll see what happens with that. Chris Butts and Brad Moore, both representing Southeast interest, are on the committee, have been appointed to the committee, but they've not met yet. So we'll see where the new administration picks that up. For our issues, moving quickly to our core issues, 2024 Farm Bill, production ag supports moving the bill forward as quickly as possible. It's likely to roll the first to second quarter, but we'll cover the 2025 crop year whenever we do it. House Ag has passed a bill that has some good things in it for crop insurance, for fruit and vegetable, tree nut. Has a disaster block grant authorization provision, which is what we want for this disaster bill. So that would be good that if it goes all the way, that there'd be a template for disaster bills that would help us guide block grant activity where we wouldn't have to fight for it in every ad hoc disaster bill. Specialty crop research and research and marketing block grants are all good for Georgia fruit and vegetable, and we support it, and they're included in the bill. There's a bonus point in that specialty crop did not advocate for, and that is in an effort on row crop to establish a base reform to participate in Title I farm programs. As farmers have gotten more diverse in the Southeast, there's a provision that says that if you also grow specialty crops and meet a certain snapshot of time in planting, 15% of your specialty crop acreage can be converted to your farm historical base acres. And that will be of value for those growers that have some row crops in the Southeast, but also grow specialty crops. So they'll pick up 15% in a base allocation for farm program participation. The House Ag Bill now has more energy after the election results. Should be in good position to be strong with the Senate discussions whenever that happens, hopefully early on in 25. What's missing? Seasonal import provisions. Both Congressman Austin Scott and Sanford Bishop have seasonal import bills in the House and have been working with us on trying to move forward to address seasonal import problems we've had with fruit and vegetable growers. In the Senate, John Ossoff has introduced a bill and has been working with us and has held meetings throughout Middle and South Georgia on this issue. Senator Warnock has also supported our efforts with with trying to get it in the Senate bill. So there are opportunities coming up for this issue in both the Farm Bill, but also in the appropriations process. We're going to move an FY 2025 appropriations bill before December 20th, likely to include or will move separately will be supplemental appropriations legislation. So there are multiple vehicles to include a seasonal import program. This will be very important for our fruit and vegetable growers in the Southeast. And we have made it our top priority. It is a tough issue, has lots of opposition from different quarters, but we have a strong team and we're hopeful that we can be successful. Separately, and this is where this gets a little confusing, economic disaster assistance legislation was offered by proponents from Alabama trying to move assistance to row crop, particularly cotton growers. That is now expanded throughout the country where every Title I or safety net program commodity supports it. And what we're hoping is that there will be some type of specialty crop economic assistance package to ride along with that. We've been discussing with some members, the House Committee, looking at CFAP 2 that many of you participated in 2021 as an option for vegetable and fruit growers to also get some type of economic assistance in the appropriations process between now and December 20th due to high input cost since COVID that have not gone away, as well as low prices. Finally, on ag disaster assistance, Georgia and Southeast specialty crops took a significant hit with Hurricane Helene and other storms. Disaster state members have been meeting with appropriators, talking to them throughout since September when the storm hit, trying to determine where do we get the money and how it should be distributed. Our message has been that we need to get this done by December 20th. It needs to be included in whatever appropriations bill or legislative vehicle moves before December 20th, and that it needs to be distributed for specialty crops via state block grants to departments of agriculture in the state. This worked in post-Michael, and for specialty crops in Georgia and the Southeast, and we're hopeful to get this process again going. Thank you very much.
Bob, I'm going to try to encapsulate several questions that had to deal with trade and imports, but we've got a couple of different versions of the bill floating around, and a couple of mechanisms where we might be able to move those. Do we see the Trump administration being any more involved or willing to engage on trade issues? I mean, clearly he's talking about tariffs to begin with, but where do we see all that playing out?
Clearly, the Secretary of Agriculture and the U.S. trade rep under President Trump his first term, understood our seasonal import problem. First, the U.S. trade rep pushed to get seasonal import language included in the USMCA agreement. It did not hold. Mexico, as you know, opposed, and then Canada piled on and they took the language out. That was our first shot. We met multiple times with the U.S. trade rep team and USDA team, both the secretary, Sonny Perdue, and in the case of U.S. trade rep Lighthizer, assigned team liaisons to Georgia fruit and vegetable and Southeast growers to try and work through this. Multiple ideas on the table. What came out of that was both virtual hearings in Florida and in Georgia, trying to hear from growers as to how best to move forward. What came out of that was the blueberry case, and later a research effort on peppers and squash, cucumbers, that Chris, you were part of. But on the blueberry case, that was the signature way to get through this. We had the election in the middle of it before the decision, and the blueberry growers lost, unfortunately. But there will be no learning curve with the team they put in place at the department or with the U.S. trade rep on the seasonal import issue. And we've really struggled here on this issue with the administration. And I'll use this as an example. Over a year ago, Senator Rubio put forward the Federal Advisory Committee a committee to look into the seasonal import area. initiated by Senator Rubio. It took forever to put the committee together. I don't believe there's been a single meeting to date on by the FACA or Federal Advisory Committee. That's a long way to go. Once you start meeting, a year, 2 years before you have any proposals, and then you're likely to have to go back to the Congress to get it. So it would be a long path for success. What I'm hopeful is that we're going to have a lot of trade activity in the first year. There's no question about that. Whether you would have to know, watching any social media or television, you'd have to be aware that we're going to have a lot of activity in the tariff space. How do we fit in this process? Our advocates that have been our advocates on the seasonal issue with Congressman Austin Scott and Bishop in the House and others, Buddy Carter and Rick Allen, David Scott, as well as in the Senate with Senators Warnock and Ossoff, they are still there. And we're hopeful that we'll see the kind of activity that we've been desiring with a new team in place.
A lot of changes, I think, is the one thing that we're most certain to experience over the next couple of months. So,
yes.
Okay. All right. Thank you, Bob. We're going to transition now over to Kimberly Hermann from the Southeastern Legal Foundation. We are so pleased and proud to be working with Kimberly and her team. When DOL released their latest set of rules last year, we immediately recognized it as a bridge too far and an overreach on authority by the Department of Labor. So we were extremely grateful to work with Kimberly and her team. And as I mentioned earlier, we're wrapping this up and bringing closing arguments to the court by the end of the month. So Kimberly, I'll turn it over to you and let you update us on where we stand with the case. Thank you.
Yeah, thanks, Chris. I see a lot of familiar names on here. I know that our VP of litigation, Braden Busek, has been doing a lot of these updates. But let me just make sure you guys know who we are. So Southeastern Legal Foundation, we are one of the country's oldest public interest law firms on the center-right side, if you will. So we challenge government overreach. We sue the federal government and state governments when they violate your constitutional rights. So it's very exciting work, and we are honored to get to do this and to partner with amazing clients like GFVGA on a regular basis. And so just a recap of this lawsuit, in June of 2024, we filed this lawsuit in the Southern District of Georgia on behalf of GFVGA, Milesbury Farm, and we joined with a coalition of 17 states, where Kansas is the lead state on the lawsuit. We filed the case challenging the H-2A rule, which you all are also familiar with, so I'm not going to rehash any of the rule. I do want to just remind everyone what the judge has done in this case to date, and then talk about where we're going and how a new administration could maybe change the case and also won't change the case based on what we're expecting. So in August of 2024, the district court, which is going to be the first court that hears this case, right? So that's where we make all of our primary arguments. The district court granted a preliminary injunction against the Department of Labor's rule, saying, Department of Labor, you cannot enforce this rule with respect to the members of GFVGA, Milesbury Farm, or in any of the 17 plaintiff states. And so right now, for all of you, this rule is completely paused, which means that it's status quo from before January of 2024, or that's what it should be in effect, right? We know that they've been trying to play a few games behind the scenes, but that is the effect of the ruling. So what did the judge say, and why did the judge issue this preliminary injunction? We brought a few key arguments to the table. The argument that the district court agreed with at this point was that the Department of Labor didn't necessarily have the authority to issue this rule. And I'm going to talk about what I mean by that, because there's two arguments that we made with respect to whether they have the authority to do this, but that they weren't able to extend the H-2A benefit to the subset of agricultural workers that were specifically excluded in the NLRA, right? So in other words, Congress came out with the NLRA. They said that agricultural workers were excluded from the NLRA, And what we have here is we have the Department of Labor unilaterally trying to give a certain group of workers, so H-2A visa workers, these benefits, right? If you want to call them benefits, I don't like using that word, but we're in a room here with friends. And so that's how they would refer to it. How I would refer to it and how the court has referred to it is that they did not give these H-2A workers the right to unionize, right? And so that the court agreed with us there that the NLRA is very, very clear. And if Congress wanted to do it, then Congress could have done it. Another argument that we made is that the Department of Labor doesn't have the authority to issue rules under the immigration laws, which is how it's claiming that it has this authority. The district court didn't go that far. It basically said that at this point, it wasn't going to make that ruling, that whether or not this was a ministerial action or whether this was a substantive action was something that it wasn't going to fully explore at the preliminary injunction stage. And that is something that we have kind of teed up for appeal, which I will kind of talk to you about a little bit more. A few things to note about the actual district court's ruling that I think are really important when we look at what's going to happen under a new administration. The district court used very, very powerful language with respect to who has authority to do different things with labor law and with respect to H-2A regulations. It specifically said that administrative agencies like the Department of Labor cannot create the law, which is exactly what the Department of Labor was trying to do here. It ignored Congress's very clear intent and very clear plain text of the law. And it said that Congress has the right to do that, not the Department of Labor. Okay, that matters because a question that we're getting a lot right now is, well, what's going to happen? Is the Trump administration just going to walk away from this lawsuit? Can they issue an executive order? Can they change the rule? An executive order would not be able to fix a final rule that the Department of Labor has put out. We need to litigate this case to the very end. And as Chris has alluded, we're very, very close to doing that. We are trying to get that preliminary injunction to be permanent. We have filed a number of briefs with the court, as has the Department of Labor. And right now, it's really just sitting on Judge Wood's desk and in her chambers to make a decision as to whether or not she's going to make this injunction permanent or vacate the rule entirely. If she makes the injunction permanent, that means that the injunction would most likely apply to the parties in the case. So the Department of Labor would not be able to enforce this rule in the 17 states or with any of the plaintiffs and the plaintiff's members, which include all of you. If the court goes ahead and vacates the rule, then the rule would be gone for the entire country. That is what we're ultimately asking the court to do. But as you understand, we have no power other than making our arguments, and we have no crystal ball to know what Judge Wood is going to do. And so we just kind of anxiously await that. Because this is a final rule, the Department of Labor could come back in and they could issue a notice of proposed rulemaking to change the rule. They would have to take public comment on it, and then they would have to finalize the rule again. Why don't we like that as the only option? Once a judge rules on this and says the Department of Labor cannot do this because this power lies with Congress, right? And Congress has been very clear, then we have precedent where a future administration that maybe is not favorable could come in and just do this again. And we see this issue where the agencies flip-flop back and forth in everything that we do, right? In all the issue areas that we work on. We don't like that. And so we want to get really strong case law precedent that says, agency, you can't do this, end of discussion. That gives us a finality in what is happening here, especially in this area where Congress has already said what falls under the NLRA and what it doesn't. If you're talking about other issue areas, maybe Congress hasn't opined on it yet, then there might be some different strategies. But again, because Congress has been so clear here and the court is agreeing with us on that, we want a final ruling. When we get that final ruling, under a Trump administration, we don't expect them to appeal it. We don't have interveners in our case, which potentially changed the landscape of how things would look on appeal. There have been some very unique situations where courts have allowed interveners, so people that come in and say, if the administration isn't going to defend this rule, we are going to defend this rule, and we have harm to defend it. There are unique and rare situations where interveners can come in at an appellate level. It is not unheard of. It is unlikely, given the fact that the court here has already declined to let interveners in, but anything could happen. If we did end up winning, but still ended up at the 11th Circuit on appeal, we also don't necessarily hate that, because there is the overall issue as to whether or not Congress has delegated the Department of Labor certain authorities here. And we would then get to litigate those issues and get finality on those. And so we just really see ourselves being in a great position in this case right now. We know there's other cases that are going to be discussed here. I'm happy to answer questions, Chris, if you have any on the case. But there really hasn't been a whole lot of movement since our last update, other than the fact that we can kind of see the light at the end of the tunnel here. And right now, we think we're sitting in kind of a win-win situation.
Kimberly, are there any indications in terms of the judge's ruling and making it just the 17 states or vacating it nationwide? Do they have a preference as to, do they like to make those nationwide decisions, or would they prefer to make it more targeted?
It really depends here. The relief, I mean, to not get into legalese, but the relief that we're asking, there are some different standards that are applied to each of them. So there's a different legal standard that the courts look at. So in other words, when I say standard, it's you have to establish A, B, C, and D for a preliminary injunction. You have to establish X, Y, and Z for a vacatur. So the standards are a little bit different. We believe that we have really strong arguments for vacatur here. We would prefer vacatur. And in other cases that we've brought that are in different areas, say against like the CDC eviction moratorium back in 2020, the courts were agreed to vacate the rule because it affects so many people throughout the entire country, and because we could establish that. It's really hard to say here. I wish I had a crystal ball. We're hoping for vacatur. We're hoping for that in all the cases that we've brought. But at a minimum, you all will be protected through this. And there are other cases, which I know we're going to talk about with the next presentation. So
last look at your crystal ball, any
yeah.
idea in terms of timing, in terms of how long it'll take Judge Wood to make a decision?
She's a really efficient judge. And so I will say, we've litigated WOTUS in front of her. We've litigated other cases in front of her. She's a very efficient and thoughtful judge. And so I would hope that we have a ruling by the end of 2025. These judges are all aware that we're going to have administration changes, right? We don't want them to make decisions based on politics, but they also don't live in a vacuum. They're human beings, and they understand kind of that they need to move things in their courtroom quickly and swiftly. And so we're hoping by the end of 2025. We have no way of knowing. The only other thing that I would mention, since you guys were talking about disaster relief earlier, and maybe we can answer this at the end. I don't want to take the focus away from H2A, but we do have other cases where we represent the agricultural industry challenging disaster relief programs and other programs where people are excluded because of the color of their skin or because of their sex. So they're discriminatory programs, and the courts don't like it when the USDA discriminates against farmers and against our growers. And so that's something to kind of keep an eye out for. Don't expect that in the new administration, but there are so many programs already in place where you simply may not be able to get disaster relief or the economic relief that you need and that you should be getting under our Constitution. And so that's something that we also do here at SLF, where, if you see those, bring them to Chris's attention, bring them to our attention, because we may be able to help you out with challenging some of those.
Thank you, Kimberly. As you alluded to, we also have just a bevy of other ongoing H2A cases across the country. I'm sure you've all heard mention of the Chevron decision earlier this year by the Supreme Court and the impact that may have on our ability to bring about some change through the court. So in the last few months, we've certainly seen a large number of cases filed centered around H2A. And Chris Schulte is here with us from Phillips, newest member of their, I guess, ag labor team. But a name that is known to many of you guys. Chris has been involved in the H2A and ag labor front for many years. So with that, we'll turn it over to Chris to give us a look at the H2A cases pending around the country and how those may impact everything else that's going on with the new administration and everything else. So Chris, we'll turn it over to you. Thank you.
Thanks, Chris. Happy to be part of the Fisher Phillips team and part of the Georgia fruit and vegetable team now. Thanks for coming out this morning, everybody. Just a quick update. There's sort of two fronts. One, building on what Kimberly was talking about. Because you were so successful, it made the other states jealous. So that she mentioned that there were 17 state attorneys general that were part of it. So if you were in kind of the redder third of the country, we'll say, the injunction covers you, and you don't have to worry about this. The other 33 states, not so much. And so we've run into issues where there are states that straddle the state border between kind of a state that's in the injunction and a state that's outside. And they run into trouble and had to file different job orders and figure out ways to comply with two different sets of rules at the same time. So we've had folks on the Illinois-Missouri border with land on either side of Mississippi, and then Idaho, Oregon, one state in, one state out. So there are at least 3 other lawsuits all looking to kind of build on what you've achieved and kind of achieve nationwide effect. There's one in North Carolina. We'll try to expand it there. There's one in Mississippi, down in Gulfport, that includes the AFBF, Farm Bureau is trying to kind of give it nationwide scope. The Chamber of Commerce is a part of that one. And then there's one in Lexington, Kentucky, where it's NCAE, which would essentially be nationwide. They cover about 85% of H2A employers, and WAFLA to kind of expand it out into the Northwest. So there was a hearing a week ago, Monday, in Kentucky, and there's one next Monday down in Gulfport, as they look to kind of build on that and kind of see what they can do. Judges lately have been a little bit squirrely about nationwide injunctions. There's been a trend recently to kind of limit it to the parties before them. Not in every case. I mean, there's some in Texas recently where they issued nationwide injunctions, which makes sense. If the law is illegal, it is illegal, and so the APA talks about the rule should be set aside, not kind of, it'll be set aside depending on where you're located, and it can be simultaneously legal in one place and illegal a mile away. Doesn't really make a lot of sense, but we'll see. So between the 4 cases now, including yours in Brunswick, we're hoping to kind of nail the lid down on that rule. In kind of other H2A, the other kind of, apart from the program requirements being a burden, kind of union access and all the progressive discipline nonsense that we know from the new rule, the big complaint we always get is the wages and how it's just gotten out of hand. On 2 fronts, the kind of the new OEWS, they call it, so it's the Occupational Employment Wage Survey that the Bureau of Labor Statistics runs, for things like truck drivers, supervisors, mechanics, people in livestock that have to string barbed wire to keep their cows in get called fence erectors now. So they have to be paid the same wage as people that build fences around someone's pool. So all of this kind of trend toward kind of pulling in non-ag occupations and kind of these wages that are well into the $20, $30 range. That there have been 3 lawsuits challenging that. And then the one that I'm part of down in Tampa is also challenging the kind of the regular Big 6 adverse effect wage rate that's based on the USDA survey. That's a survey that we've had since the 80s. And so as the program has grown and changed, the wages have gone up and up and up because more and more what they're surveying is capturing last year's results for H2A. So originally there weren't a lot of people using H2A, so they could do a survey and find out what's the actual market rate for non-H2A people and then pay that. Over time, that's kind of gone away. And so what they're surveying is essentially an echo from the year before. And so when you set the average as the floor, well, guess what? It steps up every year. And so, we end up with wages that are now pushing, 17, 18, it's almost $20 out west. The other part of it is that when the department sets wages for H-2B non-ag workers, so that could be kind of food processing workers kind of in an ag adjacent space, but also, landscapers, hotel workers, jobs like that. They set the wage and then the workers get that money and they go find their own housing. In H-2A, you get the money and you get the free housing. So essentially when they're saying your wage is $16, what they're really saying is your wage is $21. And so you're kind of, it's apples to oranges with what they're paying the US workers, what they're paying the H-2A workers. So that's part of our challenge in the case in Tampa. Very much unlike Judge Wood, our judge is not speedy. We filed that lawsuit in I think April of 23, which feels like 100 years ago at this point. And so we argued it that summer. We didn't get a decision from her until I think it was Good Friday of this year. So it took the better part of a year to get a ruling on the preliminary injunction. We've now fully briefed the permanent injunction. And so technically we could get a decision any minute now, but it could be a while. So there are two other cases that are, and so that's challenging both the truck driver, the OEWS, but also the regular FLSA work. The other two cases, one is in Asheville. That one, the judge also denied the preliminary injunction, but they took that up on appeal. And then on the separate track, we're pushing for the permanent injunction. So there's kind of two decisions they could get in that one. They're not likely to prevail on the appeal, but we're hopeful. And then they're hoping to get an injunction there. The slightly different arguments there. We argued that the kind of the language of the statute talks about somebody being similarly employed, and argued that somebody's driving, a truck full of sugarcane or peaches or potatoes is doing on a farm is doing a different job than somebody that is driving packages for Amazon from Kansas City to Los Angeles. That those are not the same job, and so making one pay, making us pay the wages of a non-farm employer doesn't make a whole lot of sense. In that case, the one in North Carolina, they're arguing more that it will promote more illegal immigration by setting the wages that way. So kind of a more policy-based argument. The third case that's challenging is down in Lafayette, Louisiana. They did get a preliminary injunction, but very narrow one. We talked about how judges don't like to give relief beyond the parties that are right in front of them. That's what happened there. So it's specific to sugarcane producers in Louisiana for truck driving. And then even within that, based on kind of getting this injunction saying kind of, hey, your rule is illegal, you're not doing it right, you're not looking at similarly employed employers, you're comparing, sugarcane drivers to people that are driving for Walmart, that doesn't make sense. The judge agreed with that. But then when they went back to DOL and said, okay, hey, good news, we won, so go ahead and recertify our wages back to the regular AWR. The department said, no, the rules say if it goes up, you pay the higher wage. If it goes down, tough luck. And so they're essentially locked into this contract. And so their season this is when they're at peak right now, from the beginning of October through the holidays, basically, for sugarcane. So they kind of didn't really get the relief that they'd want in court. So the decision's worth the paper it's written on for the most part. It's well reasoned. We cited it in our case. It came out right before we put in our final briefs. So we were able to kind of piggyback on those arguments at least, but we'll see what happens in that one. And then as far as there was a proposal to be able to expand that group so that people could be members of the it's a Louisiana Sugarcane Growers Association. So the membership was not limited. So there's a question can people just say they're a member of the association to get a benefit of that? The court limited it to people that were members as of the time of their last order. So they've essentially closed the door to it affecting other people. So it's kind of the people that won didn't get a whole lot out of it, but it is a good decision. We do agree with it. We worked with the lawyers down there and they used our ag economists to kind of submit their information. So we argued in our case, look, it's the same arguments, the same folks, we should get to the same outcome. There's no real reason why driving is fundamentally different in Florida, say, than it is in Georgia or is in Louisiana. So that's our argument. NCAE is a party to our case. So if we do win, that would cover all of you through GFVGA. GFVGA, sorry, missed the vegetables. Don't want to leave out the vegetables. So they that's the goal is if we win, that would apply everywhere. One last thing that we're working on is through NCA, they had put in a petition to acting Labor Secretary Sue to hold a hearing on the adverse effect process. Essentially saying, this is what they used to do when they'd issue rules. The department would hold hearings, they would hear testimony from economists, from farmers, from associations, kind of how is this working? What are the wages doing? Kind of take a step back, and instead of saying this is how we've always done it. And so even though wages have completely come untethered from reality, this is what we're doing. They used to look at it and say, okay, well, it looks like we're overshooting. Maybe we can adjust that, or, there should be a way to include the cost of housing, kind of ideas like that. So they put in that proposal last December, followed up with her in June and again in October. She has stuck it in the drawer and not gotten back to them. So on the screen next to this on my computer, we're working on a complaint to bring them into court to push them to give us an answer. Again, they're essentially packing boxes to get out. They're going to be gone 2 months from this week. So the idea is not so much that she would rule on it, because they're the ones that just put out this rule. I think they're probably happy with their work. They've been defending it in court, certainly. But that it would set the table for the new administration to go through a rulemaking process, take testimony from groups like ours to consider a better way to issue the rules, so that we can go to a more market-based solution. So that's the goal, to kind of like, they could take the position, look, we have to, we're being sued in court, we have to respond to this petition. And so it kind of lights the fuse for them to do new rulemaking. Some of the rulemaking really, began at the end of the last administration. And, as Bob pointed out, there's some familiar faces that are going to be coming back to Washington with the new administration. So, we're not, too, like rose-colored glasses too much that, everything's going to be fixed, but we're hopeful that we can kind of, make some headway on that and kind of, use the litigation as leverage to kind of move along the conversation about making new rules. And then use that on the Hill to, push the new Congress to actually make some of the fixes that they need to do to fix this. So they've never defined what adverse effect is. And so that's how we end up with, departments that just kind of guess that if we just pay more than anybody is making as a US worker, then there won't be adverse effect. Sure, but that's not really what, Congress meant when they passed that in '86. So if they could kind of go back in and, make some of the bigger picture fixes, then we wouldn't have to sue them 5 times a year. So that's the long-term goal, to kind of get relief kind of built into the statute by the people that are supposed to do it and not by the department.
Thanks, Chris. Question, with the new administration coming in, is there a possibility that DOL could look and say, man, we're getting court decisions coming at us left and right on these rules? Could they at any point just decide to withdraw that rule and not make it go into effect in terms of the worker protection standard rules?
So we've talked to some of the people there that, based on your lawsuit, kind of if we get to a tipping point, so instead of 1/3 of the states it's blocked and 2/3 that's still live, if it kind of goes the other direction, I think they would agree to walk that back. So the court decisions give them cover. They say, look, if we enforce it, we'd be in contempt. We can't do it. The courts, because they're getting everything that we raise to them, they're getting the opposite side from, worker advocates, legal services, TRLA, farm workers, kind of people are arguing on the other side. And so this gives them cover to say, look, we can't enforce it. But we've heard from them that if it gets to a point where it's just unworkable to have 2 rules like that, there are a few more states where we get it enjoined, they would walk it back. They can't just sort of do it automatically, but they can kind of suspend enforcement of it or do it through which forms they will use. This happened in the handoff from the George W. Bush to Obama. The Bush team put out an H-2A rule in, essentially it was published in, I think, January of 2009. So right as they were on their way out the door, it went final. The Obama team said, we don't like that. We're gonna pretend it never happened. We're gonna walk that back. They were sued by North Carolina growers, who said, no, you can't, like, that's the law. You can't change the law, without following the right procedures. So the department lost in court. They had to kind of walk that back. And so that's where we ended up with the 2010 rule that we all kind of grew up using kind of for, but it took them about a year to kind of get that new rule out going through the comment period. So essentially whatever it takes to make a rule is the same process it takes to remove a rule, but they can walk back some of the enforcement provisions. So the way that they're doing for the states that are covered by the injunction, you are still using the 2002 form instead of the 2024 form that they're using kind of in other states that aren't included. If that makes sense.
So in the AWARE, just the last couple of years, we've in Georgia, we've looked at a 22% increase, and I think we're expecting another one. And unfortunately, those have tended to come out the Friday after Thanksgiving on Black Friday the last couple of years. So we've got that to look forward to. But the pending cases that are out there, if any of those are successful, would those roll back the AWARE rates or the OEWS methodology to a previous time if any of those cases are successful?
It would. So the one where it was successful already in Louisiana, they were only challenging the new wages, so not the survey ones that are going to come out next week, I think, and then kind of take effect shortly thereafter. The good thing for Georgia is that because you're covered by the injunction, one of the things that's enjoined is that immediate effective date as opposed to the old 2-week lead time. So whenever that's published, I mean, it's not super helpful. You'd rather it didn't take effect at all, but you at least get, kind of a 2-week grace period, and other states don't. But so what they did with the OEWS wage is that they said, okay, that one is illegal, so you can just go back to the regular AWARE. But the way the department is applying that, it's only if you, for your next certification, you can use the AWARE. But if you already have a contract in place where you had to list that wage, you're stuck with it under their rules. In ours, where we're trying to get rid of the FLS AWARE, you make them come up with a whole new methodology altogether. Don't even use the USDA average. The idea is that they could keep that in place until they completed the rulemaking, or we could come up with some other placeholder so that it's not kind of everybody goes back to $7.25 an hour until they sort it out. Like there will be some way to calculate it and as a bridge to them doing a new rulemaking, coming up with a better wage.
Very good, thank you. Okay, looking at the clock, we've got a few minutes where we could entertain some questions from the audience. We don't have any in the chat box, and I think we've covered most of the ones that were submitted. Bob, I'll kind of put you back on the spot and ask you to pull out your crystal ball, if you don't mind. Do we see this Congress as, it seems like every 2 years we come together and we say this may be the year for immigration reform. Do we see the stars aligning with where this may be the year for some sort of meaningful ag labor reform?
I think once the border issue is resolved, that we could see hopefully ag labor reform or H-2A reform start to move forward. But we're similar position we were the last Congress and the one before, where that's going to be the tip of the spear. It's going to have to happen first in some form, and then we would hopefully track. But there's a lot of interest in it. We came close, as you know, a couple of times, but we have so many different organizations involved in it. Everybody wants to inject, usually toward the end, and we end up blocking it. But I'm hopeful if we'll give it the full cycle of the entire Congress that we've got a shot at it.
Yeah, very good. All right, well, we don't have any other questions in the chat box, so we're going to give everybody back about 5 minutes of their day, and hopefully you can go have a nice lunch. But I think it's clear to see the next few months are going to be pivotal for the industry. Change, I think, will be the one constant that we're looking at, and we've got a lot of irons in the fire. But I think the good news is that we're starting to see some movement on some of these issues, and we will continue to work with our friends and allies and colleagues across the industry to try to bring about meaningful change. So hope that provided some good information for you, some insights as to what the next year may look like in terms of the impacts of the election and everything else that we have going on in the country. So thank you to our supporters and our sponsors and to everyone else, and hope you have a great afternoon, and we'll talk to you soon. Take care.